Hello, everyone, and welcome to the next episode of Rock the Closing. Today, we have a very, very special guest who will talk about mediation for people going through divorce. So, we have a family law attorney with over 30 years of experience protecting the rights of individuals. And I really wanted to emphasize that she is a family law attorney protecting your rights. And the way she's doing it through mediation, which is, I think, fantastic. And she has a phenomenal story to tell and help us to navigate real estate in divorce proceedings. But let me introduce to you Alla Roytberg, and she is the owner of Roytberg Traum Law and Mediation PC. Alla, tell us, the Rock the Closing listeners, how can we find you? How can we find your law firm if we need your services? Please.
So I'm very glad to be here. Hello, Orsolya. Hello, Dalia. Very nice to see both of you. So as Orsolya mentioned, I'm a founding partner of Roytberg Traum Law and Mediation PC. I've been a lawyer and a mediator for over 30 years. My firm began in 1996, and we have offices in Manhattan in the Chrysler Building, in Forest Hills, in Nassau County, and most of the work that we actually do online these days. We provide legal services in New York, New Jersey, and Connecticut, and mediation services nationally and internationally. So the best way to reach us is our website, which is goodlawfirm.com. Our phone number is 212-582-5757. And the text could be sent to my cell number, which I freely give for text purposes. Doesn't mean that I pick it up every single time. And that's 917-374-7475. So that's the best ways to reach us. We're a mother-daughter firm. I'm the mom. My daughter practices with me. She is also a partner at this point. And we focus our practice on helping people stay as far away from the court system as possible and resolving all of their disputes outside of court. And when it comes to legal services, we're primarily focused on family law and anything under family umbrella. So it could be, some real estate, some trust and estates, a small firm startup. But our approach is specifically to keep people as far away from conflict as possible. And the way we do it is by trying to anticipate potential conflict and making sure that we can find ways to resolve it before it happens.
That sounds amazing, Alla. So in keeping with the primary practice that you have, we would love to ask you some questions about how that sort of ties into real estate issues. So my first question to you is, when a couple separates and there are some real estate assets, maybe a family home, those things can be a major point of contention. So how does mediation help the separating couples navigate decisions about whether to sell, whether to keep, how to divide, when to do that, all those kind of things? How does that tie into what you do, and how can you help?
Sure. So, as a famous writer, Leo Tolstoy once said, all happy families resemble one another. Each unhappy family is unhappy in its own way. It was an opening line to Anna Karenina. But that's, we take this kind of sentence very seriously in my practice, because when it comes to any kind of family and divorce separation issues, the first question is to figure out what are the options. And there are different options on how you can separate or divorce in New York State. At one side of the spectrum, a couple can sit across a kitchen table and resolve everything. At the other extreme is a litigated divorce process, which takes years, hundreds of thousands of dollars, and nobody is happy, and hostility escalates. And results and solutions are not necessarily ideal. What happens in a matrimonial divorce process, as Dalia, you may know because you have background in this, is that you go to court, you have a discovery process where you go back and forth and you try to figure out what's out there, how do you evaluate it, whether there are primary real estate assets like a home and a vacation home, and then you can have investment real estate assets, and you have to value everything and to figure out what's in the marital pot, what could be separate. And then you start figuring out, well, is there going to be a buyout? Do you defer a sale? Do you have shifts of all of that? Problem is, when you do this in the courthouse, it's hostile. Each side's attorney's job is to just advocate the best scenario for their client and kind of the worst scenario for the opposite side, right? And what ends up happening is you get a settlement, but you can get a settlement at the 11th hour on courthouse steps right before a trial. And it's not well thought out. So you can, in a litigated process, after spending time, money, hostility, all of that, you can end up with a settlement agreement that says we're going to have a buyout of something. We're going to have a deferred sale or buyout, which means you co-own for a time and then figure it out. But what happens is, when I'm seeing these agreements, a lot of things get missed. And especially in the real estate provisions, there are so many loopholes. So in a deferred sale, you could have people that, okay, we're going to live in the house. They don't put the time frame. They don't put who pays for what. They don't put in what would trigger an unwinding of this marital asset. They don't put in a process. What do we do? Is there a buyout? How much time do we give each side to try and do a buyout? If that doesn't work, do we then select a broker? How do we select a broker? How do we decide on a price? So all of these things, it's like almost like doing math. You need a flow chart, and very well as real estate attorneys that, like what happens and what goes into the real estate process. Unfortunately, matrimonial attorneys often don't know that. And you then get stuck years later trying to help them navigate a real estate transaction where there's so many loopholes and unknowns in the agreement that they're following. So in a mediation, we have the time and we have the ability, and it's more of a problem-solving process that they voluntarily opt into. And each asset we're looking at, and we're trying to figure out what's the best solution. We work through all of these potential what-ifs and flowchart issues, and we have the ability to write that in. And the other big issue that happens very often in matrimonial litigated cases is they don't tax impact, which is a big problem. So they could divide a house. Let's say somebody does a buyout, and it's a 50-50 buyout based on equity. Let's say the wife buys out the husband's interest, for example, for a certain amount of money, and they calculate it as a 50-50, but she doesn't intend to keep the house for a long time, but she decides that 3 years later, 5 years later, she's going to sell it. Well, unless they figure out and adjust for capital gains, she's going to bear all of the responsibility for the capital gains as the new owner. And then it's no longer a 50-50 split. So those kinds of things, it's just mediation gives the opportunity to kind of think through and methodically and in an amicable way solve each one of these issues.
Thank you, Alla. That's really insightful and brings me to my next question, although you have addressed some part of it. But what are some of the biggest financial and emotional pitfalls of litigating real estate issues in a divorce? And how does mediation offer a better alternative?
So the emotional piece is usually related to a family home. Someone says, this is my home. I want to live here all my life. I want to be able to afford to live here all my life. And, sometimes in a litigated process, you have one spouse that kind of is done. And then you have the other spouse that is not done and was basically kind of hit over the head with the concept of divorce and is not even able to negotiate in their best interest in a rational manner. And you get all kinds of crazy situations that happen. That's why people end up with orders of protection. It's like War of the Roses. I had a case once where the couple cohabited. It was a litigated divorce, and they fought over everything. They fought over every item, every plate that they had in the house. And, there was no rational piece to it because they were paying more to their attorneys than the items were worth. But it was completely emotional. Also, judges are not going to be great with very creative solutions. They have specific solutions. You sell, you divide 50-50. If you have children, maybe you defer the sale and somebody stays in the house until the children finish school, and then you sell or do a buyout. But in mediation, there are additional ways to think creatively. So, for example, let's say you have that wife that buys out the husband's interest. She doesn't have the money to buy out the husband's interest. So how do we handle it? If there's no equity, how do we handle it? Well, there are ways to handle it. You can consider prepaid support as a lump sum offset against the amount of money that would need to be the buyout. You could, if there's a deferred ownership, you could consider some other things. For example, let's say you have the wife staying in the house, the husband moves out, and they're going to co-own for, let's say, 3 years, 5 years, etc. The husband is still on the mortgage. He's concerned, what if he's paying support and the wife is defaulting and his name is on the mortgage? It affects his credit, it affects his equity. How do you handle it? Well, in New York State, spousal support, on a federal level, spousal support is no longer deductible. Let's say there's a spousal support component. In New York State, there's a little bit of a deduction, but not on the federal level. Well, what if the husband is paying the mortgage directly? He then can potentially benefit from getting a deduction on his taxes for the interest paid on the mortgage, which he may desperately need as a higher money spouse, and the wife may not. So there are all these things that we can implement and think through. And in a standard litigated divorce, usually they're not addressed.
Yeah, I totally agree, Alla. I have seen a real cookie cutter approach when it goes to litigation. Attorneys just are one-sided, one-minded. What's good for my client? What's worse for their client? Judges are like, okay, buy out or sell. You have 30 days to get out. And there'll be nothing written in the orders about any of these things that you're talking about. So it can definitely be a mess later. And then when they come to sell to us, we've seen people come to us and they're trying to sell their house. They're not on the title. They don't know what the mortgage company, like all kinds of stuff, because it was really something that needed to be worked out in the divorce or in a mediation, preferably, before they came to us, because it's really not even ripe for like selling their home at that point. It's like we can't even do anything here because there might be court orders against selling it or what have you. So,
Dalia, it's interesting that you say that, because I often tell, and I lecture a lot to mediators about real estate in mediation and divorce. And I always tell them, if you're working out an agreement and you have an agreement, run it by a real estate attorney. The same way as you would run an agreement by a CPA to see whether there are any areas which need to be tax impacted that, or flag. The same way, run all these real estate provisions, because it becomes a real mess. And sometimes you have parties that are really amicable and they say, oh, we don't really need this. We'll co-own. And then if we have problems, we can't agree, maybe we'll come back to mediation. And at that moment they need it. But then things can sour in the relationship, and then you are stuck on the real estate side trying to follow their agreement that makes no sense. And then they need to run back to court and do your real estate process.
Yes. Yeah. So do you have any, well, let me ask you, what is the most creative sort of solution that you've ever seen two people come up with that you didn't really expect, would happen, or something kind of new that some clients came to you about?
So the whole concept of paying mortgage kind of in lieu of support is a good one. The concept of, let's say you need to have $500,000 that is a buyout amount. And instead, and there is a problem with the cash flow on the other side for paying support, and there is a large monthly support number. So we calculate how many years it would take to pay this $500,000, and we put it together as a prepaid support credit to offset. So that on the one hand, the person who's doing a buyout doesn't need to give money. The person who has to pay support gets a free ride without having to pay support for a certain number of years. And sometimes it kind of leads into the children's emancipation almost. And it's perfectly legitimate, legal, fine with the courts, and it's really helpful to people. Because that's one of the biggest challenges, being able to have the cash flow. Sometimes people say, you know what, we want to have the kids inherit all of our properties. And they say, well, we're going to put them on trust or we'll create wills. That's another option when people say, you know what, it's fine. I don't need the equity out of this. We will continue to co-own, or we'll put it in the trust, and then we will give it to our children. Well, if they're doing wills to give it to their children, that's not so safe, because anybody can change a will at any moment. But if they set up trusts and put the ownership of the real estate in the trusts with the children as beneficiaries, then that's something they can do. So these are some of the creative ways in which, especially with older divorcing people who are, like doing in part divorce, in part almost estate planning, that works well.
Alla, that's interesting. And can I just have a follow-up question to this one? So when you recommend and when the parties agree to create a trust during the mediation process because they agree this is the best way forward for us, would you create the trust as an outcome of the mediation process, or you just agree to a document in which the parties agree that in a future date such and such trust will be created? How does that work?
It really varies. I think if we say that they're going to create the trust as an outcome of co-ownership, let's say they'll co-own, then they'll create the trust, we just want to make sure that we put a time frame on it. And that also there's a detailed enough description of what this trust does and doesn't do in the divorce agreement.
I see.
So that they don't get different ideas. Ideally, I think it would be best if they create trusts prior to signing, so that these actual trusts could be referenced in the agreement. So you can say, the spouse A set up spouse A, trust, irrevocable trust, or whatever it is for the purposes of owning this real estate with the children as beneficiaries. And, and spouse B has this trust, and we reference the trusts. That would be the best scenario. Very often they don't want to do it because it delays the process, so they agree to do it down the road.
I see. So let me flip the scenario, because trust might be a good option or preferred option of other couples whose children are already grown up, as you mentioned. But what happens if, for example, the couple has small children, they are co-owning the family home, and for the sake of the children, they want to hang on as co-owners? How can mediation facilitate a co-ownership agreement? What can be done?
So co-ownership agreement, let's say it's a family home. So we could have different options. So one of the spouses, one of the parents occupies the house, the other one leaves, or the co-op. Then the other option could be, it's a nesting arrangement. It's the home for the kids.
Right.
And if the parents have alternate residences, then the home stays kind of with the kids for as long as the kids need it. And then they decide that once the kids go off to college or, at some other time, they will then sell it, do a buyout, whatever. So the nesting arrangements are popular. They're usually in the best interest of the children. Very often they're done in higher net worth families because obviously you need to have, two separate residences and the ability to support the main home for the kids. So there's more money that is needed. So that's, those are some of the options. So again, in mediation, none of this would happen in a litigated divorce because a litigated divorce, the outcome is they're solving a problem of this moment. So let's say the kids are 5 and 10, and the court says, right now, they're going to occupy the house. The primary residence will be with this parent. They're going to occupy, and then until the children finish school, and then they will sell. The court doesn't say in the decision, you are going to agree, you're going to have a 30-day time frame, you're going to set up a value. You will, if the buyout doesn't happen, you will then have a broker and have the broker recommend a price, so they'll lower the price. And how would this happen? The court doesn't do any of this writing in their decision. They basically say, right now it's this until the child is 18, then sell it. Then what happens is when the time comes, the person who's in the house may say, you know what, I'm not moving out. I'm not doing it. Go sue me. And 9 times out of 10, they end up back in court. And at that point, the court says, okay, you came to us now with this issue. We're going to solve it. The same way as the college. So like if you have 5-year-olds or 10-year-olds and there's a divorce, the court is not going to address college. They're going to address child support, extracurricular expenses, child care expenses. And they'll say, you know what, when it's time for college, come back and we'll address college. In a mediation, the agreement covers it all, from the moment of their birth until after they're emancipated. It also covers if somebody has special needs. Maybe the parents want to support their child past the emancipation. So there are all these things that could be looked at. And that's what the court's job is you came to me for X, I'm giving you X and no more. And I'm not thinking tomorrow, if you need something else, you come back and then I'll address that issue.
Yeah, so it seems like the mediation is really comprehensive. You really look at every, all 4 corners of the agreement and all the what ifs, right? So my question is pertaining to the asset that they have, the real estate asset. Do you ever work with real estate professionals or real estate attorneys to sort of piece together that portion of the agreement so that, what's going to be needed in the future, or if there's some sort of down the line buyout or whatever, like how can we frame this, or who should stay on the title, or whatever the case is, so that there aren't any issues down the line when it comes time to do the closing?
Absolutely. And I think everybody should be doing this. Mediator is like a family doctor who flags the issues, addresses the main agreement, and then, here's the tax issue. Let's get a financial professional in to figure out what the right answer is, and the real estate attorney in to figure out what the right answer is. And if we need a valuation, let's bring in the broker and figure it out. And if we need a valuation of a business, let's do that as well. They do it in the court process. The difference is that in a mediation, they're opting into it voluntarily, and all of these people coming in are usually neutral. In a court process, even if the court appoints an appraiser to value a property, one party is invariably not going to be happy with it. And they'll say, well, no, I want my secondary appraiser is going to say something else. The same thing with the lawyers, the same thing with the accountants, because it's an adversarial process. So yeah, so absolutely. I think it's critically necessary to have a real estate attorney review the terms of the deal and say, okay, you know what, but did you think of this? I'll give you an example. Co-ops, big issue. I'm seeing these agreements. Okay, they'll do a buyout. They'll do a buyout if one spouse has a certain amount of time to buy out the other spouse. They say nothing about board approval. A lot of the time, they forget that there is that little wrinkle. Is it okay? Is the board going to approve that one spouse that you want to transfer ownership to, that there is a board process? What about the costs? How do you share the costs? Flip tax, the word flip tax doesn't exist in any of these agreements, but it could be a very significant cost. So absolutely, I've seen a lot of agreements that divide up property, do buyouts, have buyout language, refer to deeds instead of stock and lease, where it's a co-op. And they really don't understand the refinance situation in a co-op where the mortgage company is the one that holds the original stock and needs to come to the closing. You can't just transfer ownership. It's I think it's one of the bigger mistakes that usually get made in litigated divorces with co-ops division.
Oh, co-ops are my absolute favorite. I so much love the co-op dynamics. Let's put it that way. I really enjoy working with co-ops, and you are hitting the nail on the head. Exactly yes, there is the co-op board, and there are special rules applied to the co-op.
And then there's business judgment rule. They don't need to explain why they refuse something, and people don't understand. It's like, how could that make sense? I have everything there is. Why are they denying me? Well, they're denying you because they can, and they don't have to explain. So
for now, yes, they deny you.
Transfer tax is another big miss in a lot of these agreements, because when you do a buyout, people seem to think, a lot of matrimonial attorneys seem to think that it's an intra-family transfer and there are no transfer taxes. And that gets missed. And then people get really upset. What do you mean I have to pay transfer taxes? What do I pay transfer taxes on? But, there was no money changing hands. So why should there be payment for transfer taxes? And then there's a fight over whose responsibility it is.
And then there are the closing costs, which can be also quite hefty.
Right. Some closing costs could be the bank refinance costs, and some could be transfer fees. Now, bank refinance costs depend on the loan that the person that's doing the buyout chooses to get. So should the other person have to pay or pay half of this if they don't have any control? Somebody wants to take a loan and pay, 2-3 points to lower the rate, and then the other person would then have to pick up half of those fees. So most matrimonial lawyers, I don't know, Dalia, if you encountered this, in matrimonial processes, they don't even think of these things.
No, they don't. They absolutely don't. I mean, they'll just go as far as saying, well, when should it be sold, or who gets what percentage of the purchase price. There's never, some kind of breakdown. The most detailed one I've ever seen was like some timeline in which to list it and some price that it can't go below. And that was like, in that world, that was just so detailed, but really it was like not even scratching the surface. Yeah.
Well, thank you so much, Alla. I actually have a final last question, which we should have probably asked at the very beginning. But considering that probably not all of our listeners are attorneys, could you just give us really basics about so if someone chooses to do mediation instead of litigating a divorce, during a mediation process, how many attorneys are involved or how many attorneys are necessary? That's one question. And the second one is, all right, you mediate, you come to an agreement at the end of it. is that the end? Is that putting the stamp that the couple finally made it and they are divorced? Or does the outcome of a mediation process has to be stamped by a court?
Okay. So in a mediation process, it's a voluntary process. So when somebody reaches out to me and they say, I'm interested in divorce, sometimes they say mediation because they know about it, but a lot of the times they don't. They say, I'm interested in a divorce. Very first thing that I do is I send them this informational email and I say, well, here are your options. And I tell them about mediation. I tell them about collaborative divorce, which is another process that I am involved in. This week is Divorce with Respect Week for collaborative divorce. So all the collaborative professionals are telling everybody what collaborative divorce is. But in a mediation, so if they decide to participate in mediation, I'm a neutral. I'm a lawyer. I have background in matrimonial law, but for the purposes of the process, I'm a neutral. So I provide them with neutral legal information, which basically means, well, if this doesn't work out and you go to court, then the range of possibilities could be from here to here, whatever. But I always tell them and encourage them to consult with their own individual attorneys before start of the mediation sessions. If they don't have them inside the mediation sessions, at least get a divorce consultation to understand your individual rights and responsibilities from an attorney that only gives it to you. And then, so in the process, the number of meetings really depends on the two of them. They could meet with me several times and then say, you know what, we're going to sit there and we'll figure out all these items on the checklist and we'll be done. Then there are others that may need months and years. But once the goal is to get to a point where all of the issues are addressed that are relevant to them, whether they're real estate issues, support issues, parenting schedules, custody, all of that stuff. Once they reach a consensus on all of this, that means I'm ready to draft an agreement. I draft the agreement as a neutral. I email the draft to both of them. I offer them a session to review the legalese in a neutral setting. And then I strongly suggest that they go to their review attorneys to kind of look at it. The reality is that a lot of it depends on what they want to do. I don't mandate attorney participation. I sometimes would mandate it if I feel that there is a power imbalance.
Mm.
But at the end of the day, the attorneys may come back with input on language. Ideally, they don't try to break up the terms of the deal, and they're mediation-friendly lawyers. If they have some substantive disagreements, we come back and mediate those substantive disagreements. But then I finalize the agreement, they get it signed and notarized. And once they have a signed and notarized agreement, we can call it separation agreement, divorce agreement, settlement agreement, doesn't really matter. At that moment, they're legally separate. And that marks the end of the mediation process. Okay. If they can choose to live pursuant to that agreement forever as a contract for a certain amount of time, and sometimes they decide to do that. For example, if one spouse is covering the other's medical insurance, and they want that to continue because it gets cut off at a divorce. And sometimes they say, no, we want to proceed with the divorce. If they want to proceed with the divorce, we do provide services for an uncontested divorce filing for a flat fee, and that's how, it ends up going into court. The agreement itself doesn't need to be stamped by a court. It operates as a contract. When they're doing an uncontested divorce, the divorce is uncontested because everything has already been divided and decided in this agreement, and the agreement just gets attached to all the other documents, and it's really purely a bureaucratic type of a filing. And nobody needs to contest, nobody needs to revisit. Everything is already done and set, and it's just a matter of time until our, overburdened court system processes the documents and issues a divorce judgment.
Yes, the waiting. It's always the waiting. But at least everything's signed and sealed and delivered to the court, right? Amazing. Okay. Thank you so much, Alla. We cannot express how grateful we are to have you. We've had plenty of guests, and we are so happy to have someone with so much knowledge to come on our podcast and share this information, because we just, we're real estate experts, I would say, but there's so much stuff on the periphery that is actually also really important to real estate law. And you really seem to have so much knowledge. So we would love to thank you so much for joining our podcast. And to our listeners, we thank you so much for listening and for tuning in. And we will post Alla's information on our website. If you need any counseling or any advice, just give her a call. It's Alla Roytberg. The website is www.goodlawfirm.com. And I believe the name probably speaks to the service. So, well, thank you so much. And we will catch you next time on our next episode of Rock the Closing. Have a great week, everyone.
Thank you for tuning in to Rock the Closing. This podcast is hosted by real estate attorneys who offer valuable insights. Please remember that the content is for educational purposes only and does not constitute legal advice. Always consult a qualified professional before making any decisions. This podcast is copyrighted by Rock the Closing, and any reproduction, syndication, or rebroadcasting of the content requires written permission.